Hello, my name is Mohammed MP. Today we'll be exploring in detail about one of the important organs of government, legislature. We have already looked at the various features and sources of the constitution. As you will know, we follow a parliamentary system of democracy. This means that the legislature and legislative process are of utmost importance in our democratic scheme. But what is legislature? Legislature is the law-making body of the government. The primary functions of the legislature are to formulate laws and policies for the governance of the country. They also act as a powerful check on the powers and actions of the executive and even on the judiciary by providing a platform to critique its actions and programs. In fact, in many cases, the decision of the executive often requires legislative sanction to be lawfully implemented. Under our constitution, the parliament and state legislative assemblies constitute legislature. This means that the parliament is entrusted with the lawmaking functions at the union level, while the state legislative assemblies are entrusted with lawmaking functions at the state level. As per the scheme of our constitution under Article 246, the parliament has the exclusive power to legislate upon subjects under the List 1 of the 7th schedule. List 1 of the 7th schedule is also known as the Union List. Similarly, the state legislative assemblies of various states have the exclusive power to legislate upon the subjects under List 2 of the 7th schedule. List 2 of the 7th schedule is also known as the state list. However, both the parliament and state legislative assemblies have the power to legislate upon subjects under List 3 of the 7th schedule, which is known as the concurrent list. Though the powers to legislate upon subjects under the concurrent list are shared between the union and the states, it is subject to the doctrine of repugnancy under Article 254 of the Constitution. Doctrine of repugnancy simply states that if there are any conflicts between a law enacted by Parliament and a state legislative assembly on a subject under the concurrent list, the law enacted by the Parliament prevails over the law enacted by the state. Let us take an example to understand this. One of the entries under the concurrent list is criminal law. This means that a state may enact a criminal law for application in the state. However, if the law enacted by the state conflicts with the law enacted by the parliament, the law enacted by the parliament prevails over the law enacted by the state. However, under Article 254 Clause 2 of the Constitution, the state may overcome this by securing the assent of the president as opposed to that of the governor of the state. Let us now explore the institution of parliament in detail. Chapter 2 of Part 5 of our constitution deals with parliament. It is the legislature of the union. The parliament in India is bicameral, which means that it has two chambers, the Council of States or Rajya Sabha and the House of People or Lok Sabha. Rajya Sabha and Lok Sabha are also known as the upper and lower houses of the parliament respectively. The nomenclature upper and lower house is historical and does not actually reflect the powers of these chambers. In fact, in most democratic countries these days, the lower house usually commands more power than the upper house. An example for this is the concept of money bills under the constitution, which can only be introduced and passed by the lower house or Lok Sabha. This, however, does not mean that the Rajya Sabha is entirely toothless. Although we often think of the parliament as only Lok Sabha and Rajya Sabha, Article 79 of the Constitution states that the parliament consists of the President of India, Lok Sabha and Rajya Sabha. This means that when we refer to the parliament, we refer not only to the Rajya Sabha and Lok Sabha, but also to the President of India, whose assent is essential for a law to enter into force. This also means that our constitution, the President has limited legislative powers, such as in the case of ordinances. Before we delve into ordinances, we must first understand the role of President as part of the Parliament. Under Article 85 of our Constitution, it is the President who summons the Lok Sabha and Rajya Sabha for session. The President is also entitled to prorogue or discontinue a session of the Parliament. The President has also been entrusted with the powers to dissolve Lok Sabha from time to time, which usually happens after general elections are held in the country. None of this, however, means that it is actually up to the absolute